Supplementary list. Announcement of judgment. Item number 1.
The courts of the considered view that in view of the compelling circumstances and for the ends of justice, written statement filed with petitioner should be accepted by the trial court. Consequently, impugn orders shall stand set aside and quashed. Trial court should proceed to dispose of the matter most expeditiously. Preferably a period of 6 months from the date of this order. The parties put to notice to appear trial court on 14 March 2024.
Any mention?
May it please your Lordship. Lordship, I beg to mention item 18 of the hearing list.
For upgrading?
No.
My Lord, I appear for the respondents, my Lord.
Why? This matter has been hanging.
My Lord,
Your Lordship, let it come next week, Your Lordship. Monday or Tuesday.
my Lord, I have no objection
Is
to
there unpaid dues?
Your Lordship.
Okay, after 1 week, yes, under prayer. So senior is not here.
No, Your Lordship. Highly obliged.
My Lord, I beg to mention mention memo for Thursday, my Lord. This pertains to a stay of transfer and posting, my Lord, because there's a threat to the life of the young lady officer, my Lord. Yes, my Lord. 2 attempts were already made against her life, and now she has been posted to a place where it is even more insecure place, my Lord.
Been filed?
It's going to be filed in the course of the day, my Lord. Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 26, Lordship.
26.
Yes, Your Lordship.
Yes. You
Your
have to
Lordship.
file an application. You see, what mentioned
Yes,
for
Your
what?
Lordship. I have filed, Lord.
Yes?
Yes, Your Lordship.
For adjournment?
Yes, Your Lordship.
Why?
Your Lordship, the conducting council is not keeping well, so I have just...
Who's the
just
conducting
been informed.
council?
Santanu.
It's fixed for what today?
For
It's
hearing, Your
fixed for
Lordship.
hearing in the miss case.
What, 711 petition?
Yes, Your Lordship.
Yes, Your Lordship.
Okay, we'll pass orders. Yes. Yes.
Obliged, Your Lordship.
Yes.
May it please, Your Lordship. Lordship, I beg to mention item 32.
Number?
32, last item. Lordship, I pray that this matter...
Have you filed affidavit? It's filed.
Lordship, let this matter may become up after 3 weeks, Your Lordship.
Why 3 weeks?
The conducting seniors, by
Loudly? Can't hear you.
next month he will go out station, so...
So next month he is preparing for going out of station.
Yes.
In 3 weeks time.
3 weeks, Your Lordship.
Okay, 3 weeks, yes.
Highly obliged, Lordship.
Yes.
Please, Lordship. Lordship, I beg to mention item 22, my Lord. Mr. Council.
Who's for the petitioner? Yeah, objection?
Trying for 2 weeks, my Lord.
No objection, Lordship.
No urgency? Okay, 2 weeks, yes.
Obliged.
Lordship.
Yes.
May it please Your Lordship. Your Lordship, I would like to mention item number 28.
My Lord,
What's
I'm
the
for the
matter
state
about?
respondents.
I'm appearing on behalf of Mr. Hassan for respondent number 6, Your Honor.
What's the matter about?
My Lord,
It's a ACP benefit, Your Honor.
Okay, 2 weeks, yes.
Okay,
Yes. Follow the list. Not stopping
Please,
also.
Lordship.
but yes.
Lordship, I beg to mention item number 27. And for respondent number 1. 27.
Lord, I'm appearing for the appellant.
Lordship, I pray for 2 weeks'
This
time.
one wants whom? Mr. Pinongpri.
Yes.
Why?
Umesh. Private parties.
Your private parties.
Yes.
You have no objection, Mr. Khan? No. Okay, 2 weeks, yes. Follow the list. Okay. Yes.
Lordship, I beg to mention item number 21. Your Lordship, here the settlement is under process, Your Lordship.
What happened? The record's not with you.
My dear Lordship, the parties are trying to have a talk of settlement.
The settlement, talk settlement.
Yes, Your Lordship.
Okay, at least after 3 weeks, as parties submit that their talks was out of court settlement, yes.
Obliged, Lordship.
Unending, yes.
Lordship, I beg to mention item number 24 and 25.
This is finished. Why you want to mention the matter? What's the matter? It can be finished. You have the brief with you.
Your Lordship, the conducting counsel S.K. Hassan, he's under medical treatment. So due to
He's under?
medical treatment, he has some health problems, so he has to go to the hospital.
You argue next week. After 1 week, yes. 22
Lordship.
matter.
Much obliged.
Yes. Yes.
Your Lordship, I'd like to mention item number 29.
What is this, eh?
I'm for respondent number 678.
You're for whom? For the?
Respondent number 678.
You're for the petitioner? Who's for the petitioner?
Sorry.
Who's for the petitioner? Yeah.
I'm for the state respondents.
What's the matter about?
It's regarding the society.
Cooperative society.
Cooperative society.
Why are you seeking time? You're on whose
Your
behalf?
Lordship, I'm appearing on behalf of Miss B.S. Nongbri. She's out of station, so 2 weeks' time may be given.
John would not need for a taking. Yes. Okay. Enough. Call out the matters.
Pleasure.
Yes.
May I please, Your Lordship?
Yes.
I beg to mention item 19.
19. Whole list is gone. Okay, 1 week, yes. Since
Lordship,
all have taken time. Yes.
Similar prayer for item 30. We have filed the rejoinder today.
Number?
Number 30.
30.
30. We have already filed the rejoinder. I'm pretty that is Marta Maker.
You have objections?
Just received, Your Lordship, the rejoinder this morning.
Okay, after 1 week, yes.
Obliged.
Supplementary list.
No point in weekly list. Yes.
Supplementary list, item number 2.
I'm appearing for the petitioner in this matter.
Completion Act. Yes.
Because this is a case where the Learned Commercial Court, Shillong, has rejected an application on the jurisdiction of the Commercial Court to extend the mandate of the Arbitration Tribunal under Section 29 capital A of the Arbitration Act.
Yes.
It was our case before the Commercial Court that only the High Court of Meghalaya has the power to extend the mandate of the Arbitration Tribunal. That was not accepted by the Learned Commercial Court, and in this regard, if Your Lordship permits me to take Your Lordship to Section 29 capital A of the Arbitration Act.
Lord, I am appearing for the respondent. I'll await my learned friend's argument.
29A, right?
Well, Lords may see 29A is
time limit.
No, yes, time limit for arbitral award. One says that the award shall be made within a period of 12 months from the date the arbitral tribunal enters upon reference. And Lords may directly see 4. If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. Lords may just note unless the court has. And
Yes.
the question that Your Lordship has to answer is that
What is the court?
What is the court? And in this regard, Lords may just see section 2. Because section 2 being the definition clause is important in this regard.
Yes.
And my lords may see section 2E.
1 second. Court means?
Court means in case of an arbitration other than international commercial arbitration, that is domestic arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of arbitration if the same had been the subject matter of a suit but does not include any civil code of a grade inferior to such principal civil court or any code of small causes. Because that is not in dispute that Meghalaya High Court does not possess an original civil jurisdiction.
Yes.
What the trial court omits to appreciate that section 2 is preceded by section 2.1. My lords may just have 2.1. 2.1. And 2.1 says, in this part, unless the context otherwise requires. And so, as a general rule, it may be the principal civil court, but if the context indicates towards a different court, then it would become that court.
How do you say that? How do you say that in the context others requires is a different court?
Yes,
Even it's clear says
now,
that the principal civil court, if we're talking about original jurisdiction only, so any court which has civil court original jurisdiction will have the power. Yes?
Rightly so, my lords. And then, for this reason, I may take your lordship again back to section 29A and now to 29A subsection 6.
Yes.
Subsection 6.
Yes.
While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all of the arbitrators, and if one or all of the arbitrators are substituted, the arbitral proceeding shall continue from the stage already reached and on the basis of the evidence and material already on record. And the arbitrators appointed under this section shall be deemed to have received the said evidence and material. So, while exercising the power under section 29A, the court has the power of substituting and appointing a new arbitrator.
So you see section 11 is attracted?
Yes. And now Milords may see in this context section 11.6. 11.6, Milords is aware, section 11.6.
Yes.
11 is appointment of arbitrator and 6 is where under an appointment procedure agreed by the party, a party fails to act as required under that procedure.
Yes, Mr. Pandey, one thing is that why you trying to divorce the meaning of 11.6 will stand on its own footing, and this section 2.1e and 29e will be a different footing because it talks about original jurisdiction. So how can you say that the context will mean that if the High Court has the power to appoint arbitrators, so it'll follow that even if there's to increase the arbitral time, that it'll come back to the High Court again? How do you say that?
I say so because, my lords, what will happen in this situation is that the process of substitution is inextricably linked with process of appointment of an arbitrator.
Yes.
And my lords may notice one thing, that there may be a situation which has been contemplated by various judgments of various high courts, that an arbitrator may be appointed by the, let's say, this Honorable High Court, and thereafter he will get substituted by the District Court. Similar situation will happen in cases of international commercial arbitrations, where the Honorable Supreme Court appoints an arbitrator and thereafter the District Court will substitute and put someone else.
No, we'll examine it then. Yes, we'll list it for admission hearing. When?
Yes.
Let me go through the list. Go through the
my
matter.
Lord may keep it. My Lord may keep it for the 5th. If my Lord may give me just a very short time.
Yes.
My Lord, this is a matter which has been pending for an extremely long time. It's an arbitration, my Lord.
Yes.
And in fact, both sides, my Lord may recall, have already approached my Lord in different ways. There is a marked delay occurring in the arbitration The 29A application in ordinary course is usually a very procedural application. It has to be decided one way or the other. And as far as substitution is concerned, the petitioner has not even indicated as of now whether they wish for a substitution, my lord. Okay. Now, the order was pronounced of the commercial court on the 16th. It is their case, and on that date, they indicated that by the 23rd, they will file their reply, and on the 27th, which is today, the matter was listed for arguments. They did not file their reply. I think they presumed that a stay would be coming to them for granted. I'm not sure. However, the matter is listed today, and now at the last minute, at the nth hour, they move before my lord and try and use this. So my only request is, my lord may keep it for next week, may keep it for the 5th, and my lord, we can hear it and dispose of it in detail.
Milords, I have no objections for if your
go through the papers also, yes.
5th, and secondly, just a rejoinder to my argument. It is in fact correct that the order was uploaded on order was passed on 16th. But it was mentioned thrice before the learned district judge, and only then it came to be uploaded.
We'll not go into that. Yes, I heard Mr. Pandey, counsel for the petition.
May have it on 5th, and yes. I'm requesting
you Mr.
till the next date of hearing.
Anshuman Pandey, my lord.
You're both Pandey.
I'm requesting till the next date of hearing, the learned trial court may hold its hands.
My lord, that is one thing I object to. They are yet to file a reply. Let them file their reply in the meantime, my lord, without prejudice to my lord.
What happened before, because once the matter is fixed before this court on the 5th, I think normally the trial court won't take up the matter. That's it. Yes. Right.
So my lord, may yes, my lord.
That yes, Pandey, the counsel petitioner, issue notice. Mr. Anshuman Pandey is present on behalf of the respondent. No further notice required. List the matter for admission hearing on 5th of March. Yes.
Grateful, Pandey.
Grateful.
Item number 3.
Mr. Datta, I didn't give you unlisted permission yesterday because a lot of things are happening.
Yes, I understood.
Yes.
Well, my lord, the matter is with regard to award of a contract for construction of a stadium. Now, the stadium, the impugned order is at page 55, last page of your lordship's brief.
Yes.
So it is dated 4th of July 2023. 15th February 2024. Now, the tender notice was floated on 4th of July 2023. And the reserve price was 2,87,89,896. That was the reserve price. 4 bids were received, and out of the 4 bids, my lord, all the 3 private respondents, they submitted exactly the same figure, exactly the same bid. My bid was 10,000 more than what the private respondents had submitted a bid. Now, there was a stipulation in the tender condition that the bid will remain valid for a period of 90 days. And within this period, my lord, there will not be any change in the pricing or in the terms and conditions of the bid. Now, even thereafter, after the expiry of 90 days was approaching by the end of October 2023. And therefore, without getting any response from the respondents, my lord, I filed representations asking for that since the bids are almost in the same line, 3 bids are on exactly same figure, my bids being 10,000 more, then what is the criteria that you are going to adopt for the purpose of selection of the bidder? There was no response, my lord. Few correspondences ensued thereafter. And lastly, on 15th of February, I submitted the final representation to them, saying that unless you respond on my letter or my correspondences, I am going to take recourse of law. And on the same very day, my lord, this order is issued.
What order say?
This order of
order.
Yes, work order. Now, what is significant in this process is that, my lord, from the work order, it appears that there was a price negotiation even after submission of the bid.
Where is that?
My lord will kindly note the amount on which, my lord, the contract has been awarded.
2 crore 87.
2 crore 87. Now, if your lordship will kindly come to the tender, that is at page 26. Page 26, Your Lordship will find 4th July dated 2023. That
One
is,
second.
has Your Lordship got it?
Yes.
Page 26, Your Lordship will find the estimated value, 287.89, exactly the same price. Now, this gentleman, the respondent number, page 40, Your Lordship will find the bid submitted by this gentleman who has been awarded with the contract. And the typed page is at page 39. Typed page, second paragraph, Your Lordship will find, we agree to keep the tender open for 90 days from the date of submission thereof and not to make any modification in its terms and conditions. Sum of rupees 287.90, that is 1%, that is the earnest money is 1% of the bid value, is offered. So his bid was 2,87,90,000. That was his bid. Now, from the work order, my lord, it appears that there was some price negotiation between the parties even after submission of bid. And if that be the case, my lord, then I am entitled to a consideration of my bid if the same negotiation was also offered with me.
Where do you say it appears the negotiations there?
Now, my lord, I am saying that it appears from the contract, my lord, there was negotiation because his bid was 2,87 lakhs and it has been offered at 2,87 lakhs 90,000 and it has been offered at 2,87 lakhs 89,896, which was
the difference.
Therefore, it indicates that there was a price negotiation after submission of bid.
That is not discernible. I mean, 287,900 fine, but then what is the difference, Mr. Datta?
Now, your Lordship will kindly see the award has been.
Can't get it, yes.
The work order has been priced at 287,89,896,
yes.
And this was the reserve price.
Yes.
This was the reserve price.
Yes.
Now, out of
price, estimate value as per the tender notice.
Yes, as per the tender notice, that is their price. But this gentleman offered a price of 2,87,90,000, which is slightly higher than the reserve price.
Yes.
And that was the exact price quoted by all the three private respondents. My price was 10,000 more. They quoted 2,87 lakhs. I quoted 2,90 lakhs.
The amount is minimal. I mean, from the reserve price and from the amount which the work is settled.
Now, that is because, my lord, this price 2,87 was the earnest money. The requirement of the contract was that 1% earnest money.
His quotation was 2,87,900.
Yes. Now, if he has been offered at a price lower than his quotation, my lord, it indicates that there was a price negotiation.
By few rupees.
By few rupees.
It's by 1,000. It's not even 1,000 rupees.
Not even 1,000 rupees. Then, now, my point is that, my lord, if you are going to entering into a price negotiation, then why don't you offer the same as a consideration to my case? Because my tender was only 10,000 rupees higher, and the condition was that of the terms of contract was that within 90 days there will not be price variation. Now, if you are going to vary your price, lower down the price, then if I am asked to lower down my price, I can also stand a chance. This is one point, one aspect of the matter.
Yes.
The second aspect of the matter is very crucial. That is with regard to the technical aspect. Now, my representation...
It's a two-part bid.
Two-part. So, my point was...
technical bid was never opened.
Lordship?
Was technical bid opened first?
Yes, technical bid was opened first. Open first, and all were declared qualified.
Okay.
Now, that's why I submitted the representation saying that what are the criteria that you are adopting? Because since the prices are all in the same range, largely tallying with each other, then naturally the consideration will be based on the technical qualification of the bidder. Now, what is the assessment that you have made on the technical side? There is no response on that.
Anyway, very strange case, only few rupees.
Yes.
Anyway, let me come to instructions.
Yes, only for this respondent number one. These are the main respondents. This MPGCL.
Where's MPCL?
These are from respondent number 2.
You served notice to the Standing Council.
MP, it was served yesterday, Lordship. The copy was served on their office itself.
That is only the respondent number 1, Your Lordship.
No. The private respondent, in their office, it was served.
So that's the only ground, that there was price negotiations, and you not called for it.
I was not called for it, and all the private respondents had offered exactly same price. Your Lordship will kindly see page 39, 41, and 43. Same price without any variation.
There's a cartel.
Yes, that is my point. In my writ petition also, my lord, I have said that there is a cartelization. There is a cartelization.
And who's appearing? Where's MS Colney? She's the standing counsel for corporation, correct?
I take notice, Lord. I take notice.
Oh, you're
I
there.
will ask. Yeah, I'm there. I will take notice. I have not received the copy, but I need some time, Lord, to go
Yes,
through
you
this.
come with instructions. You heard
Yes,
Mr. S.
Lord.
Datta, Learned Counsel for the Senior Counsel petition with so and so. Finally, for the petitioners, submission notice. Mr. H. Abraham is present on behalf of the respondent number
1, Your Lordship.
1. The Learned Advocate General with whom?
It's
You
R.
can't
Conley, Your
accept,
Lord.
you can't accept notice here, Advocate General. Who's
No,
there
no,
with him?
Mr. Conley, Mr. Abraham, Mr. Conley can.
I accept notice on behalf of
We also accept notice on behalf of respondents. That means 2 to 8 steps we've taken on the respondents within 3 days. So we listen after 1 week. Then come instructions.
My lord, I'll just pray for a
Settlement of the contract will be subject to the result of the further orders of this court.
the construction is yet to begin, my lord. It is only we are only within a very shortest period of time.
1 week. They won't do anything. Yes.
Daily list, item number 1.
1 week, yes.
So after 1 week. Obliged.
But Mr. Datta, this is a very fine line case. Yes. You see, you can make a case out of it, yes.
My lord, as per the last order, my lord,
Where's the you file a mentally
state
objection?
respondents are yet to file, my lord.
Why? Yes,
Service was not complete, my lord. Service was not complete on 3 to 11, my lord. And we need.
My lord, from the online portal, it's showing, my lord, that they have received, my lord, some of
online portal.
My lord,
No, you suppose I objection to maintainability.
Yes, I will file, my lord, because this is regarding questioning the delimitation exercise, my lord, which is election matter, my lord, and therefore I am seeking some more time to file objection. 1 week we will file the objection, my lord.
What about the other respondents, Mr. Chanda?
My lord, KGDC has filed their objection, my lord. In fact, they have filed a 711.
No, KGC, that means they are represented by Mr.
Senior Advocate
who, by M. Sino Clau, yes.
My senior is on VC.
Yes?
He's on VC.
He's busy.
VC.
Oh, in BC. Yes, Mr. What to do after 2 weeks?
After 1 week, lordship.
Let be 2 weeks. They will do it for that. Mr. Learned Advocate General is present on behalf of the respondents number 1 and 2. MSC Cloud present on behalf of the other respondents. They brief allowed 2 weeks time to file affidavit of objection. Oh, objection to maintainability. Just thereafter and so on.
Item number 2.
Meet the lordship.
Yes.
This is the matter regarding, my lord, matters pending before.
Yes.
Concerning MLA MPs. The report was.
The report is furnished to you. Yes, what do you have to say?
Your lordship, the trial is proceeding, my lord. Your lordship may review the progress after 1 month, my lord, after 4 weeks.
As directed by the order dated 8/2/2024, copy of the report has since been supplied to the Office of the Advocate General. It is submitted by the Learned that the cases are proceeding and that perhaps the court may make a review after 2 months. Yes, accordingly, this is matter after 2 months for further orders.
Right, my lord.
Item number 3.
Item 3.
Yes, Your Lordship.
Yes, he prepared. Yes, what's the matter
I'm praying
about?
for some commission for today. As
Too many adjournments from your chamber now.
Lordship, I'm praying that this matter may come tomorrow, subject to Your Lordship convenience.
What's the matter about?
No, this is because
If it can be disposed of, no problem. No harm will be done to you. Yes.
There is an order from this court, Your Lordship, on the order dated 8/9/2022. That order was set aside. The judge of the district council was set aside because there were some irregularities, and that there was a direction to take up this matter by some other judge. That para 4 of the judgment, page 23, Your Lordship. There, may I just,
judgment?
From this court, Your Lordship. There is a direction, Lordship.
In the petition?
Yes, in this petition. In my
Why
petition.
the miss case? The miss case dispose of matter?
Lordship is kindly, Lordship kindly has page 22 of the main miss case.
Yes. Yes. Yes.
CRP number 23 of 2022.
Yes.
My lord, at page, paragraph 4,
Lordship.
the next page, direction was passed, my lord.
Yes.
Accordingly, miss appeal number 2 of 2019 is to proceed before the concerned court in accordance with law.
Yes.
This was the direction, my lord, and if Lordship kindly has...
However, as informed the court, Assistant District Judge, Assistant Judge's Counsel, for Inspector Matter, yes.
Yes.
And what happened?
Thereafter, my lord, if Lordship kindly comes to the order of 3rd of August in this matter.
Miss case.
3rd of August.
You can sit down, man. Yeah, no problem. Don't worry. Yes. Yes.
3rd of August order.
Yes.
Mr. P.T. Sarma, learned constable, the applicant submits that when this matter was disposed of by this court by order dated 8/9/22, it was directed that the miss appeal number 2 of 19 was to be proceeded in accordance. So, my lord, it appears that it was still being adjudicated by the same judge.
No, court means like by the court additional judge. Then?
Thereafter, my lord, Lordship will kindly come to the next order of 21st. It appears that the miss case was transferred, but the title suit was
Still with the assistant judge. Yes, so why you aggrieved? Only the appeal was transferred to the court additional judge. The main case still lies with the assistant judge.
No, because
then you file an application for additional judge for stay of these title suit before assistant judge. Then this additional judge is higher than the assistant judge, correct?
This court, this direction was actually, this same court was taking the main case as well as the miss case also at that point of time also.
No, who's taking up the main title suit now?
Main title suit. No, she's the one who is taking up the same case because I have
now you're submitting that the main title suit is being taken up by assistant judge as also the appeal.
Yes, Lordship. See the page 26 that list they have given. Just to clarify. Same judge taking for the miss case as well as for the
Where is that? Case. Page 20?
Page 26, serial number. This is the course list prepared. Title suit number 8, 2013. Janu K. Sangma versus Marta B. Sangma.
Yes.
So this is they have taken for now. It is for evidence. At that
point of time. That's the main title suit. We're not talking about the appeal. Miss appeal was transferred to additional judge. Correct, was to be tried by additional judge. The main title suit, no orders were passed by this court.
I will get a clear instruction.
No, nothing to get instructions about. It happens so many times when a miss appeal is filed, then you come here, then it's asked to be taken up by the additional judge. That time there was no judge, I think, something like that.
Yes.
And this title suit pending before the assistant judge will continue. If you have any grievances, then you go for additional judge and ask for stay of this title suit. It was affecting your appeal.
So now they have filed the subsequent miss case in this miss case is to transfer the entire title suit.
No. We'll dismiss the miss case.
I will just get a clear because there what I got the instruction is taken up by two cases. She has been taken up by appeal as well as.
See, your application praying for intervention by this court with regards to proceeding of title suit number 8 by the court assistant judge. We directed, see, the only direction in that order, you come to the order again, page 26.
23.
23, see.
Para 4.
See. This misappeals about what? On what issue?
It is
Don't know.
No, miscase appeal is because they have attached my property.
So you file a misappeal against the order of the
Lordship.
assistant judge.
Lordship, they have attached saying that till the pending of the case that that property will be belongs to the sole respondent.
Okay, so that appeal is pending.
That appeal I.
So you agree with the main suit proceeding before the assistant judge also.
Lordship.
Then nothing. Then there's nothing to adjudicate here, Mr. Sangma. That court is proceeding, the trial suit proceeding before the lower court only. Before the trial court.
Only problem is that
and his appeal is pending before the appellate court.
Because the same judge, she has attached my property.
He's not taking up the misappeal. Is the same judge taking up your appeal also?
No,
on a causeless only title suit shown.
Lordship.
Then?
No, we are agreeing. Even the title suit we want to transfer.
You want to transfer it to that. How will that be?
There are two assistant judges there to some other judge because.
Or you think she's inimical towards you?
Because
you understand what inimical means?
Yes.
You feel that in a court you won't get justice.
Yes. There is a fear because she has attached our property, saying that the property, my property, should be belongs to sole respondent till this one. And the same and again the same thing. The same person is taking up the case in the title.
Did you file before who's the additional judge? Name?
Additional judge, now actually there are only two, but the judge of the district council still they have not appointed.
Who's the additional judge holding charge?
One is Vicari is the
No. That means misappeal is not proceeding.
Not proceeding.
How are you making the submissions? Mr. Deb, who's the additional judge now in Tura?
Name I'm not aware, but there is a judge functioning. There's an additional judge and there's an assistant judge. There is no judge, there is no such difficulty with the additional judges.
The thing is that I don't understand.
There only now there at present there are only
why
two.
You filed this?
Two of them.
You filed to stop the proceedings in the trial court. Because you annex this the position also which was taken recently. Correct. So you feel if it proceeds in that court, won't get justice.
That is the fear from the.
That is the fear.
We will not have any problem because if some other judge can take up.
We can't pass those kind of orders. That means you are casting aspersions on the conduct of the judicial officer. Mr. Deb, you get who's the additional judge taking misappeals, get instructions. We'll dispose of after 1 week.
Lordship. Lordship.
Item number 4.
This is a contempt. My lord, may kindly have a look at paragraph 5 of my affidavit in opposition. May I just very quickly read, my lord? By judgment and order dated 20th of November 2022, passed in this so-and-so case, directed the respondent to provide payment of gratuity to the petitioner after proper calculation. And the next part, the certified copy was received by us on 01 December. Then C, my lord, on 8 we have written for fund. And again on D, my lord, on 14 February again we have requested for fund. And at C again, my lord, on 6 July 2023 we have requested to fund. Finally, the fund has been released and we have paid to the petitioners, my lord. And
so what is there? Why you file contempt?
So like after 1 year also they were not paying, and then we have
You've been paid now?
Now only partial payment has been made for
Contempt
gratuity.
means, you see, it has to be willful violation that they're doing on purpose, that they're trying to deprive you or to violate the court
And
order.
even that
In this case, see, they've been trying. You see the annexure 1 also in compliance order so and so been worked out or so and so. Then next annexure also.
And my lord's direction were also directed us to pay provide payment of gratuity to the petitioner after proper calculation of the same. So there was no specific directions that we have to carry out within a specific period of time. So we have been trying our best, my lord.
So how much you have paid all of them?
We have. There are only 2 of them, so we have paid gratuity to both the petitioners.
Contempt,
my lord.
I'm sorry.
Deeply obliged.
Contempt means if you make out that they are violating, not doing anything.
Yes, ma'am.
But see the annexures.
No, after giving the contempts, they have started doing something. Otherwise, they would have never paid us.
That also happens. Unless you file contempt, nothing happens. Seen the affidavit filed by the respondent. From the pleading or from these materials placed therein, it appears that there has been no willful violation of the orders of this court. Accordingly, contempt is closed.
My lord.
Yes.
Obliged, Lordship.
Item number 5.
Lordship, no contempt is also made out in this case, my lord. My friend has a
Short time to find a rejoinder. I'm praying for a further 2 weeks' time, Lord.
in contempt, my lord, in contempt matter, either contempt has been committed or it has not been committed, my lord. We have shown no contempt has been committed. Earlier also, my friend has sought time, my lord.
I'm praying for a week's time, Lord, because of the little
What is in the affidavit?
So they have, my lord, our brief contention was that there was an order passed by the division bench not to allow a certain private party to do anything with coal in Meghalaya without the leave of the court, my lord. And the government has allowed them to participate in the auction, has declared them as the successful bidder. After that, we have filed the contempt, and realizing their misadventure, my lord, they have stated that we have issued we have allowed them to participate. We are not issuing them any transport challan, my lord.
So is the contempt been made out?
They have purchased, they have participated, they were purchased it, they have won the bid. We don't know.
Let me find small rejoinder. It's sensitive matter. Before we settle it, yes. 1 week for the time for rejoinder.
For 2 weeks, my lord, little.
1 week.
They are delaying it, my lord, unnecessarily because no contempt is done. Whatever my friend is saying is absolutely incorrect. Absolutely incorrect. Is complete misleading the.
Please, Your Lordship. The government has given approval for the appointment of the petitioner.
He knows about it.
I think he's aware.
Not in Lordship.
This is dated 23rd February.
Finally. Yes, today the learned senior government advocate has produced a communication. Mr. S.N. has produced a communication dated 23rd February 2024, when it's indicated that the proposal for appointment of the petitioner as assistant teacher of Rongri Kimgre, RONGRI KIMGRE deficit UP school has been approved. A copy of the same is taken on board and made part of the record. Stop. Next paragraph. In view of this development, Mr. P. Sangma submits that he is satisfied and that the petition will be closed. Accordingly, the petition stands closed and disposed of.
Item 7.
But that case, because of him fighting, that's why he got approval fast. Otherwise, yes.
Because here in the affidavit they have admitted that they are very clear that it is under process. They have taken up for regularization. They have even sent the name of the petitioner. In the para 16 and para 15, they have admitted that government have taken an initiative to regularize, and they stated that it is under the process of regularization. Your Lordship, that is a stand of the. In that case, I think they can be closed.
Let's see affidavit, Mr. Khan.
Yes, Lordship. It is so
item 7 is being handled by Madam Bhattacharjee.
Doesn't matter. Take out the affidavit.
Page para 14, my lord. In their affidavit, in opposition.
Ms. Pasai for number 4. Yeah, for 5 or 4? 4th whom?
Para 14, my lord. The relevant.
Who is Accountant General?
Yes, Accountant General.
Oh, you say. Yes, para 14.
Para 14 and 16. May I read, your lordship? With regards to the petitioner, deponent stated that continuous service for several years in department and is no criterion for seeking pension unless and until regularization of service of the government employee has been decided or approved by the government. The process of regularization has been initiated. There has been no deliberate omission in discharge of statutory duty by answering the deponent. Then 16, lordship. With regards to the statement made in para so-and-so, with the petition deponent hearing state that may be mentioned that necessary step has been taken by the respondent for the regularization of service of the petitioner, considering the fact and circumstances that petitioner have rendered service for more than 30 years to the department. It is therefore higher authority of the government education department can consider the case of the petitioner sympathetically for regularization, keeping in mind that petitioner is allowed to enjoy pension and other petitioner benefit after retirement. This is they have also enclosed the name of the petitioner, lordship. It is the annexure, page 14. My serial number is my name also is there, lordship. Prohibition. The serial number is not clear, but what is the serial? Here is not clear the serial number, but name is there. The Prohibition Sangmad, the peon. That is mentioned. I think so. 1, 2, 3, 4. 14.
Yeah, I've seen that. It's marked.
That means.
Where's MS Barasaji?
She's on. So let this matter may be listed tomorrow for final disposal.
Tomorrow, lordship, because
They'll come for some time. There are lots of time. Call her when she's available.
8.
On the last occasion, there also they have admitted it is under process. You want to dispose it, but then I was not there. That's why my colleagues in the order it says.
Who's appearing here? You're appearing.
I'm appearing.
Oh, yeah. They're connected.
Yes, watch.
Yes, connected matter. Here also they have stated this under process has been processed. The order
with the instructions.
I've
affidavit.
Instruction
on the last occasion. Your lordship has taken note of those instructions.
Yes. So where are the instructions? Are they with
page? The order it.
A copy has been furnished to the
court. No, they're not here. Copy. They're not. I mean the instructions. Let us have them.
Instruction is short from the petitioner, lordship. Last order.
Is it correct?
Yes. As per the last order.
Yes. So you're happy?
Lordship, I'm happy because they said they have taken an initiative to regularize the service of the petitioner. It is recorded even in the order also. Only court has.
With regard to district council school.
District council. Earlier he was working.
Now even for non-teaching staff also will come under that taking over act.
Yes, lordship.
They're taking over even non-teaching staff also.
Yes, lordship.
They're taking.
Yes.
Name is indicated in page number 6, serial number 5.
As the state respondents have taken up the matter for regularizing the services of the petitioner, which is the name is
his name is
Napoleon Marak.
Napoleon.
This is Napoleon.
Yes.
Oh, he's already dead.
He's already passed away. This is the wife.
Yes.
Page number 6.
Of the deceased employee, Shri Napoleon Marak. As is evidenced by the communication dated 4 December 2023, which contains the cabinet approval for taking over the service by the state government respect of non-teaching staff nothing remains for its adjudication, and the petition is accordingly closed. It is expected that the matter be processed expeditiously. Yes.
Some time frame maybe.
Do not give time frame. We file contempt.
Just some, no, we will not file contempt, but
Preferably
sometime
a period
people.
of 3 months. Yes.
3 months.
You
Lordship.
take.
Item number 9.
Highly obliged. Possible, Lordship.
Please, Your Lordship. Your Lordship, this matter we are yet to receive instruction, Your Lordship.
Yes.
Your Lordship, as per the last order, we are supposed to correct the cause title.
They have corrected, Your Lordship.
You corrected it. Who did the cause title? You have to correct cause title.
No, the petitioner.
was directed to correct the cause title.
Yes.
I'll take the instruction, Your Lordship.
Yes. What's your name?
Wanda.
Your full name?
W. Rambai.
Yes.
Yes.
MSW Rambai submits that the correction has been since carried out. Stop. MSB Pasa and MS Antoni pre-phone allowed. How much time? Yes. 2 weeks time to obtain instructions, file affidavit. Yes.
Item number 10.
Lordship, the respondent are yet to file their affidavit, Your Lordship.
Have you supplied copies of the writ petition?
My lord, I have just received last week.
What about the other respondents, 1 to 4, Mr. Abraham? You're putting 8 to 12. What's the matter about?
This is with regard to that
Electricity connection, Your Lordship.
The dispute is between the private parties.
Why are you objecting to the connection? Private respondents? What are your instructions?
Yeah, 2 weeks to file an affidavit.
No, why are you objecting? Because you object if the MP, the corporation will grant a connection. Why you don't want to give connection?
Because they are the owner of the house.
You're the owner of the house. Title suit's pending. Then why is it come here for connection? Is the title suit pending?
Yes, Your Lordship.
Then once you file in the title suit itself for electrical connection?
Why not?
If it is a pending suit, why come by writ? Anyway, yes, Mr. A. Moomin, Mr. MS, will you file? MS only will you file affidavit?
No,
Or you file?
just received the petition.
Yes, but it submits that she's just received the petition. Please that below 2 weeks time to seek instructions file affidavit for 5, 6, 7. Similarly, premium by A. Moomin. Otherwise, why are you filing in the High Court for electrical connection?
11.
Lordship, the notice has been served.
Taken steps, fresh steps.
Yes, Lordship.
Okay, office notes indicate that fresh notices have been taken on 5 and 6. Stop. What about who's appearing 1 to 4?
1 to 4 is KP Bhattacharjee.
Where is he? Who's appearing for the state? None appears on behalf of the state. Yes, this matter of 2 weeks for service report on 5 and 6 and for affidavit by respondents 1 to 4.
Much obliged, Lordship.
12.
Who's for the petitioner?
Here I have to file counter affidavit, my lord.
Yes, what's the matter about?
RS.
Who's RS Armenian? None appears on behalf of the petitioner. This matter of 3 weeks. That will be filed in the meanwhile. Yeah.
13.
Yes.
But on the last occasion, your lordship had directed me to file a rejoinder affidavit.
Yes.
I've done the same, and let's.
Yes, Mr. Datta.
Yes, I have received a copy, lordship.
Yes.
Nonetheless, if I may apprise this honourable court of the moot problem in this case. That's the proposition. Our proposition is that we've already repaid. The amount recoverable, as stipulated in the recovery certificate, has already been recovered from us. Now, the stand of the respondent bank is that some more due is recoverable from us. Now, to understand this problem, the most relevant document would be the recovery certificate. Therefore, I'd like to take your lordship to the recovery certificate itself. It's annexed by the respondents in their counter affidavit. Lordship, may kindly come to page number 10. 10 of the counter affidavit. Page number 10, the relevant table with the computation is available on the next page, page number 11.
10?
Yes.
Annexure 2?
Yes, Annexure 2, page number 11, the table at the top, your lordship may kindly see.
Page 11.
Page 11.
Yes.
Now, the three certificate debtors are the petitioners in this writ petition. Now, your lordship will see that the effective date and the order date is also stipulated there as 2017 and 2022. Now, the initial amount is provided here on the 8th column under the head amount, and the recoverable amount is provided in the second last column. 8 crores 39 lakhs 81,509. This is the recoverable amount, Mulats. Now, in pursuance of the same, they executed auction of the properties belonging.
So interest and penalties have been
Everything is included, Mulad, because this is the final amount.
Just wait, Mr. Datta, I will hear you. Yes.
Yes. Because the initial amount is also provided, and this is the RC amount. It stands by virtue of the name itself. It stands as the recovery certificate amount, Mulats. Otherwise, there would be no need to have two different columns for the same amount. Now, our contention is that this is the amount. Now, the series of auctions that took place for recovery of this said debt. Your lordship may kindly come to the writ petition filed by us. Here, lordship, at page number 26.
25, order sheet.
Page number 25 is the order sheet, but the auction proceeds are provided at page number 26.
There's no page 26. Is it?
26, your lordship.
There's no page 26. Which writ petition are you looking at?
The first one.
373.
Yes, your lordship.
No page 26. Only the order sheet is here.
Lordship, the State Bank of India statement, your lordship, if it's available. This one.
'It's page 24, 26.
24, your lordship. I apologize, it has been renumbered, I suppose. Page number 24 in the petition available before lordship. Here, lordship will see that 3 properties belonging to the petitioner have already been auctioned, and the cumulative amount that has been recovered through these auction proceedings comes to a total of 8-point-something crores. At serial number 1, sold at a price of rupees 4.43 crores. Serial number 2, sold at price of rupees 1.43 crores. And serial number 3, sold at price of rupees 2.83 crores. So the amount has already been recovered. They cannot use the DRT proceedings as a tool to circumvent the law, Milords, and inflict harassment on us. The amount
Why do you say that?
Your Lordship.
What's the additional amount they're seeking now?
They're saying that in excess of some 20 crores, in excess of 20 crores, when the recovery certificate itself provides for a recoverable amount of 8 crores something.
Okay.
This is the moot problem in this case, Your Lordship.
Did you file appeal? You file appeal? You file appeal, a statutory appeal. What do you want from this court? Against the additional demand.
But for that, we'll have to deposit another 50% of the amount.
You can file for exemption also. I think the provision must be there.
But Your
Is it there,
Lordship,
Mr. Datta?
Yes,
Your Lordship, the difficulty here is that if it was an amount which is disputed, then yes, we would have approached the DRAT against the order of the recovery officer. But here there is abject arbitrariness, Your Lordship. And on the last occasion also, I had furnished a copy of a judgment of a division bench of the Madhya Pradesh High Court, where in the same situation, an order passed by the recovery officer was assailed before the writ court and it was struck down. And today also, I have a judgment of the Honorable Apex Court of India. Here also, this judgment was authored by none other than the current Honorable the Chief Justice of India. In this,
yes,
if I may provide a copy, it's here. Here in this judgment as well, at page number, Your Lordship may kindly come to page number 30. The relevant portion starts at page number 29, internal page 29. Under the heading, maintainability of the writ petition under Article 226, Your Lordship has it. The relevant portion is at page number 31. 31. Fourth line from top, the last word, from the last word. If the state instrumentality violates its constitutional mandate under Article 14 to act fairly and reasonably, relief under the plenary powers of the Article 226 of the Constitution would lie. The principle was recognized in ABL International. However, while entertaining an objection as to the maintainability of a writ petition under Article 226 of the Constitution of India, the court should bear in mind that the fact that the power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited by any other provisions of the Constitution. The High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. The court has imposed upon itself certain restrictions in the exercise of this power, so and so, and this plenary right of the High Court to issue a prerogative writ will not normally be exercised by the court to the exclusion of other available remedies unless such action of the state or its instrumentality is arbitrary and unreasonable so as to violate the constitutional mandate of Article 14 or for other valid and legitimate reasons for which the court thinks it necessary to exercise the said jurisdiction. Now the following part. Therefore, while exercising its jurisdiction under Article 226, the court is entitled to inquire into whether the action of the state or its instrumentalities is arbitrary or unfair and in consequence in violation of Article 14. This is the exact
It's a known principle. It's a known principle. I mean, there's no quarrel with this judgment. Yes, it's plenary power.
Yes.
Correct.
Yes.
But then it has to be such that it warrants action by the court in 226. But in your case, you have recourse to statutory remedy.
Absolutely, my lord. Your lordship is very well aware that, my lord, availability of alternate remedy is not a bar.
No, will not be a bar to the court of 226. But you have to show to the court that it has been such, that your rights have really been infringed upon, that you have no other recourse, that only this court can give you that air to breathe,
Yes, your lordship.
Yes.
On the first date of hearing, I had presented your lordship with a judgment passed by the Madhya Pradesh High Court, whereby again a recovery certificate issued by the recovery officer was assailed. My lord, I'd like to import the ratio laid down in that judgment in this case. Here, my lords, the reason why we've approached this writ court is that, my lords, the final amount that was recoverable from us has already been recovered by them. Now, the reason why that was recovered was because...
the reason that they want additional amounts?
Well, that is best known to them, your lordship.
You don't know?
That is best known. They say that a certain amount is still recoverable from us, but I have exhibited to this...
Yes, Mr. Datta. What is the amount recoverable now? Yes. Mr. Datta, unmute yourself. Unmute, we can't hear you. Unmute.
Lordship. Yes, Lordship, can you hear me?
Yes.
Lordship, if your Lordship come to page number 5 of our affidavit. Page number 5.
Yes.
I'm sorry, Lordship, I'll start from page number 4. It will be easier for Lordship to understand. It is pertinent to mention herein that in terms of judgment and order dated so-and-so and recovery certificate number so-and-so passed by the learned DRT in OA number so-and-so, the certificate debtors have to pay interest at the rate of 14.80% per annum with monthly rest, being pendentalized interest, on the outstanding claim amount of rupees 839,81,509.10 with effect from 8/3/2017 till realization.
Yes.
Accordingly, the respondent have calculated the portion, the interest portion, which comes to 13 crore 85,06,365.06 as on 19/12/2023, and the total balance outstanding dues has been calculated as herein below. Page 5 here. Certificate amount is this, which my learned friend is saying, that is, this is a certificate amount. 839,81,509.10.
Certificate amount, it shows that the interest has been factored in.
Lordship, I'm coming to that also. I'm coming to
now, why did you write there with interest and
Yes,
please continue.
next, number 2 is the pendulary interest at the rate of 14.80 per annum with monthly rest and as per DRT order with effect from 8/3/2017 to 19/12/2023. Recovery made after filing of OA, it is 894,46,798, that is from selling of the properties. Now, your Lordship, let us traverse to page number 10 of the recovery certificate of my affidavit.
Yes.
If your Lordship, after the cause and title, immediately below, this recovery certificate for 839, your Lordship got it?
Yes.
839,81,509.10 in terms of final order dated so-and-so passed by this tribunal in the above mentioned case, it is ordered that the applicant certificate holder bank is entitled to recover a sum of rupees 8,39,81,509.10 with pendentalité and future interest at the rate of 14.80% per annum with monthly rest from 8/3/2017 till the date of full payment of the realization and cost of the application in OA number so and so jointly and severally from the certificate debtors. So the certificate is not amount certificate, that was the claim amount, the certificate amount. Apart from that certificate amount, interest is also there, Lordship.
Now, one thing, Mr. Datta, it's come to page 11 of the affidavit. Now, you see in this table which is shown by the counsel for the petitioner. Now, you see one column there is loan type, okay, fine. Next is interest type, more compound interest monthly. Interest rate, what you're saying, 14.80%. Effective date from 8/3/2017. Audit. Now, why did you show the amount as only 8 crore 39 lakhs?
No, Lordship. Our claim,
what is computation?
Yes, I'm explaining it very simple. When we had filed the application, the claim amount that we had filed, the claim application that we filed before the DRT is 839. On that point of time, on that same date, the amount was that.
Okay.
Because we can just write that pendant interest, and it is only for the court to permit or allow or reject our claim. So on that point of time, the date of judgment, the date of filing of the application, our claim was 839, which includes all interest. It is very clear, Lordship.
Up to that date, it includes all interest.
Yes, till 8/3/2017. Till 8/3/17, the total amount was 839.
But then when did you realize these amounts from them? By auction of the properties?
Yes. By auction, we could realize only 8 crore something.
8 crore 69, okay.
No, Lordship, it should be, to be very fair, 8 crore 94 lakhs 46,798.
Okay, 8,494 lakh. Now, when was it realized? When was the auction done?
Auction was done on 9 October 2023.
9
October
10/22. So now you're saying that the interest will be effective from 17 to 22. There's 13 crores.
Yes. Yes.
Okay, so after the auction was done, you're not factoring in. All right.
That will be deducted. We have deducted it.
Yes.
We have to deduct. The recovery, even if we do not do, the recovery officer will do it.
Yes. Right. Anything else? Yes. Yes.
Lordship, so far the maintainability is question is a question that my learned friend is harping on. Here, he can not only go for an appeal under Section 30, he can also make an application before the recovery officer itself.
Yes. Right. We'll pass orders. Yes. Anything else?
Let's see if I may make a small supplementary submission, Mulaz.
Yes,
Just
please.
with utmost humility, I'd like to submit that, Mulaz. Unfortunately, that is not how the recovery certificate works and functions, Mulaz. The amount is computed, and the amount computed here, and your Lordship has also noted that the order date is also recorded, 22, and the amount after computation comes to around 8 crores 39 lakhs. Therefore, the additional interest that they speak about has already been factored in and taken into consideration.
Clarify. Yes.
And item 14, Mulaz, is with regard to the property, one of the properties that was auctioned off with, there's certain encumbrances still present in the property, and the only...
Seeking time to remove it.
Yes, Your Lordship, because at the time of the issuance of the sale certificate, no time was stipulated, and therefore, Mulaz, we were left high and dry.
Have already been auctioned.
Yes, long time.
Yes, auctioned.
But they were never in our possession. Therefore, we did not have the opportunity to even remove them. And Mulaz, the movable properties that are present in the said property, landed property, are humongous in the sense that there are vehicles and that there are bunk beds, there are computers, and we require a huge real estate to relocate them. Therefore, some amount of time may be granted to us. We're praying only for 6 months, Lordship. Obliged.
15.
Your Lordship, in this matter, we're still awaiting instructions, Your Lordship. So I'm praying for further 3 weeks' time to
What's the
file
matter
affidavit.
about?
This is a regularization.
Regularization?
Regularization, Lordship. Delete. There's interim order pending, Lordship.
As per interim order pending?
Oh, sorry, it may be extended, Lordship.
Yes, Estim Thao also prays for further 3 weeks' time to obtain instructions. This so interim order shall continue the next date.
16.
Same matter, or similar matter.
Second call. Item 7.
Yes, Lordship.
This will close down also?
Yes, we can close it because...
What's the instructions?
Instruction, Your Lordship, because the only thing is that there correspondences going on between the school subdivision and officer and other.
Is it the same as the other case, which is that?
Lordship.
Not because they are the non-teaching.
What instructions do you have?
No, only thing is that those who have completed qualified.
No, what instructions do you have?
Instruction already that they are.
Where's the written instructions?
Written instruction, it is. I have filed my affidavit, Your Lordship. It is.
You filed very good. Let's see affidavit.
Yes, Your Lordship. I have filed my affidavit. And
in the affidavit, para 16, Lordship, they have admitted. The earlier case, in case of Marina Sangma also, is a non-teaching staff.
Non-teaching staff. But only one point is that, Your Lordship.
One second. Yes, which page?
Page 6, para 16, Lordship, they have admitted. Para 16, Lordship.
No, but they have decided to take over the non-teaching
only
staff
those who
also.
have completed, Your Lordship, 5 years qualifying service from 90 from the date of appointment to 1994 when 93.
Okay.
Okay, so but
Para?
it is in
Para 16, Lordship.
Not it is in not
Para 16.
It in annexure for annexure 6, Your Lordship, at page 14, Your Lordship.
What you said right in the affidavit, they rendered over 30 years of service.
Yes, Your Lordship. He has completed and he has retired on superannuation in 2022. But still, he has not been given. Only thing is that his service is not regularized and it is continuous correspondence.
Which annexure?
Annexure, Your Lordship. Annexure 4, page 11, Your Lordship. Where it is written that his regularization cannot be made,
Yes.
Your Lordship.
Yes.
Yes, sir. With reference to the subject above, I am directed to return here with the service book along with connected papers in respect of Sri Krebitson Air Sangma, Peon Pre-Primary Section, ADM, and to inform you that since the service of the above retired employee has not been regularized by the government, IPS 1996, 2007 and 2018 cannot be approved. Next annexure, Your Lordship, page 12.
Yes.
This is from the Director of School Education, Your Lordship. So last part, Your Lordship, may I go through, Your Lordship, whole thing? In addition, in addressing government on the above subject and with reference to your letter under reference, I have the honor to state that non-teaching staff or of primary education under subdivision school education officer, Garo Hills district, are
This
treated.
don't apply them because this is teaching in the district council school.
No, he's a peon, Your Lordship. He's a non-teaching staff.
Oh, non-teaching staff in the district council school.
Yes, only last
So
para.
5 years will be qualifying service.
Yes, Your Lordship.
That means
Only he's
teaching
short of
from
4 months.
89 to 94.
That is, Your Lordship. Now it is discussion of your honorable court and the government, Your Lordship, because I have this much instruction.
Napoleon also in the last time on the page, my learned friend, page 14 of the affidavit, one the Hemtom case, so LDA.
No, Napoleon, he was enough of service, correct?
Only he's short of 4 or 5 months, Your Lordship. This person, this Krebitson, Your Lordship, may come to page
Not
14.
Napoleon, another person, the Hemtom K.
I'm talking about this person, Your Lordship.
So Napoleon, he joined service on 1990.
Yes, Your Lordship. Your Lordship. He also joined in 1990, but only thing is that he's short of 4 or 5 months.
So where's Mr. Khan? He said that his case being considered on instructions.
Khan? Mr. Khan? Who's Mr. Khan? Khan.
Otherwise, also, my
His
lord.
name is there in the list, Your Lordship. At
Where's
page,
the name of this petitioner?
page 14, Your Lordship. Annexure 6.
Krebitson is fine. Krebitson is the earlier one. Oh, this one. Krebitson.
No, this is
No,
the
I'm
Krebitson.
talking about
Yes,
Krebitson. His date of appointment is 22/11/90. And qualifying service as mentioned in this annexure 5, page 12, that 5 years from
Yes.
June 1994. So June 94.
June 94.
So it is only 4 or 5 months short. So it is the discussion of our honorable court, Your Lordship, because he has completed 30 years of.
Yes, take down.
Yes,
the petitioner who stated to be, who said to have served as a peon,
Yes, Your Lordship.
had been appointed. Oh, chokidar or peon?
Sorry, Your Lordship. Sorry, page 2, Chowkidar. Chowkidar in the office of the assistant to the administrator 2, paragraph 2 of the writ petition, Your Lordship.
Chowkidar, Lordship.
Extremely sorry, Your Lordship.
Yes,
Paragraph 2.
The petitioner stated to have been appointed initially as chowkidar in the office of the assistant to administrator
2.
Roman 2, primary education, Garo Hills Autonomous District Council, William Nagar, on 21/11/1990. Stop. The government of Meghalaya, the state respondents, with regard to the district council schools, had taken over the primaries, had taken over the lower primary schools, or the government, the state respondents, with regard to the schools run by the district council at a primary level, had taken over the same by means of an act enacted on, which was which was brought into force on 2nd June 1994, known as the Meghalaya, in bracket, taking over the district council lower primary schools Act 1993. Stop. By the said, under the said Act, notifications were also issued with regard to the different cutoff years for the taking over of the lower primary education by the state government. The petitioner, who was serving as a chowkidar, being a non-teaching staff, by, what's that? Was the letter issued? By
Annexure.
Minority staff. Was that 2012? Where's the 2012?
2012 is annexure 5, page 12.
Yes. By
page 12 to last paragraph, Your Lordship. In view of the above.
The petitioner, as per the submissions, has been serving for over 30 years in a said school. But the terminal, he's retired now. When he retired?
Written 31st 12 2022.
22?
Yes, Your Lordship. 31st.
But no pension and other retirement benefits were accorded, in view of the fact that the state respondents, by a proposal dated 3/8/2012, bracket annexure 5 to affidavit in opposition by respondent number 5, had provided that staff to be, the non-teaching staff to be eligible for consideration for payment of pensions, benefits, etc., were to have completed at least
5 years.
5 years of qualifying service as on June 1994. Stop. The petitioner, next paragraph. The petitioner, as can be seen from the service roll and statement wherein the names of non-teaching staff have been shown. I'm sorry, Fabian?
Next is 6, page 14.
Petitioner as can be seen from the service room and statement wherein the names of the non-teaching
Are shown. Entered service on 22nd November 1990. And as such, by operation of the policy of the state respondents, the 5 years qualifying service, for 5 years qualifying, as per stipulation for 5 years qualifying service, the petitioner falls short by, that means
4 5 months. I've counted.
That's 1911, 1990,
Yes, Your Lordship,
June 6 by 7 months.
6.
By 7 months. So,
Actually 5 months.
which would otherwise make him ineligible. Stop. Next parameter. Mr. P.T. Sangma, Learned Counsel for Petitioner, submits that notwithstanding this impediment, the state respondents may be directed to consider the grant of pension benefits to the writ petitioner, inasmuch as it is not disputed that he has rendered over 30 years of service, having superannuated on, that did give?
Superannuated on 31st 12.
On 31st 12.
2022.
2022. Stop. Next, MSS Bharatchaji, learned CA, also fairly submits that it will be left to the wisdom of the state respondents to decide the case of the petitioner. Having considered the submissions and also perused the materials, it is correct that it is admitted, and materials wherein it is admitted on affidavit that the petitioner has served over 30 years. But the denial of pension benefits for a shortfall of a few months would seem unjustified. Stop. In his view of the matter, notwithstanding the decision, notwithstanding the stipulation of qualifying service of 5 years, as a petitioner falls short by a few months, the state respondents are directed to consider the case of the petitioner sympathetically, and if pension benefits be granted, the same be not treated as precedent. Stop. The consideration between when the process of consideration should be completed within
4 months, Your Lordship. Within 4 months, Your Lordship.
Within 4 months from date of order. So, with about what directions the representants dispose of is.
Much obliged. Only thing, Your Lordship, I may be allowed to submit that respondent number 1, 2, 3 are the state respondents, and 4 is the.
Oh, 1, 2, 3 is.
Much obliged, Your Lordship.
Hearing, item 17.
Please, Lordship. Lordship, this is a part-heart matter with regard to that poultry appointment pensionary benefits. Yes.
Yes, your submission is not today.
My Lord, I was to take some instructions regarding service rules, my Lord. So, my Lord, I've consulted the department. They don't have any other than the ministerial rules, service rules, 2017.
Where's Mr. Kurishi?
He's in a meeting, Your Lordship, due to that bar.
He's holding office. He's
the assistant secretary of the bar, yes, Lordship.
We'll take it up when he comes. When?
Lordship, Please to, yes, because matter was heard also, and then Lordship has put some certain queries to them whether they have the rules or not, and
No,
since
that
he has
is-
clearly
that is our
stated that
instructions.
their instruction that there is
Because
no
see, the
rules,
thing is that the veterinary doesn't have any rules.
No, my lord, they don't have any
How?
independent rules. That is exactly, my
They're
lord.
they're following these rules.
My lord, they are following the Meghalaya Ministerial District Establishment Service rules, my lord. When it comes to the district office, and for the directorate, it will be the directorate service rules, my lord.
on the last day of vacation, Lordship has gone in detail also how he was appointed, and then after the
Gone in detail,
eligibility test.
forgotten everything after vacation.
Yes, so
Yes. Let's see. You had an authority on like because the
They were supposed to show some authorities.
The fault is not because of you are not to blame at all. They say that they have admitted due to oversight. Now, whether this financial benefits been given to you can be taken away. Are you doing recovery from his pay also for the excess amount?
Oh, no, we have not, so far we have not passed any order of recovery, my lord. Our stand was that, my lord, that he has to be reverted back to the to his old
that
post.
also after his
Old post.
After superannuation.
Yes.
But as far as recovery, my lord, we have not stressed on that. At least so far, my lord.
So, poultry attendance equivalent to what?
Beyond post, my lord. It's a grade 4 post.
Okay.
And there is, here actually there is no scope for promotion also, my lord.
So, he is poultry attendant, retires poultry attendant.
Yes, my lord. Oh, matter may come up next week, my lord.
Now, where's the offer memorandum you referred to? You said that it's a violation of overlooking office memorandum. How do you rationalize these kinds of cases where they put to a test and they qualify initial appointment as a poultry attendant?
My lord, that should not have been. My lord, in an affidavit, of course, we have, para 6 onwards, we have stated, my lord.
What have you stated?
My lord, that with regard to the averments made at para 2 of the writ petition, the answering deponent states that on the basis of the petitioner holding the post of driver, his age of superannuation is due on 30/9/2019. However, while processing the settlement of pension benefits, it was detected that the appointment to the post of driver was not under the provision of service rules. Therefore, the department wants to make arrangements by
You get authority.
revert him back.
I told Mr. Kureshi last time. We'll have it tomorrow.
Lordship.
Tomorrow.
Tomorrow I have
We'll
some.
dispose it off. With or without.
Can it be day after, my lord?
Today is Tuesday?
Yes, my lord.
Okay, day after tomorrow.
Yes.
That's a fixed matter. I just do my own research.
My lord.
Since I'm not getting assistance from the lawyers.
23. Much obliged.
This is a matter regarding disability pension, Lordship. On the earlier occasion, Lordship had observed that he is eligible for pension, Lordship. The only question the respondent had raised was 60% ceding, Lordship, but as per their own clarification, which is non-existent, Lordship. Lordship. In their affidavit.
Item 23.
Item 23.
Item 23. Ajay, I think 1920. 20 is John. I'm not 23. What's item 20? I was wondering. Yes, the items. The other item before that, mistake.
Sorry, my mistake, sir. 20.
Down. Huh? Yes, Mr. Shah, you studied the judgment.
My Lord, I have studied that judgment. It directly does not cover this case, my Lord, because that was of RCW. My Lord, there was a scheme by the state government, and the writ petition was filed for challenging the other things, my Lord. Here it is a case, my Lord, where the stand of the respondent is there is no sanction post, my Lord, and the petitioners has been serving for last 30 years, my Lord, on a daily, on a part-time, Lordship.
What to do, Mr. Jha? Can a manifest issue?
Definitely.
If they clearly part-time?
My Lord, I have the authority.
How? What authority you have? You've got new case, law?
My Lord.
Very good. So Mr. Jindal has allowed to meet those.
Yes, sir.
Let's see.
Yes.
Is it reported? Must be. Reportable. Where's the citation?
Citation, my Lord, I have searched, I could not.
Very old case.
My Lord.
Yes.
Page 3, my Lord.
Yes.
My Lord. Even the part-time.
Well, that's the Punjab High Court. What happened? What is said in this case?
My Lord, in the case of Girdhar Lal, my Lord, there is observation page 3, my Lord. If I take my Lords to page 4.
Yes. See, Mr. General argued last time that they were part-time only. They came into the appointment with the eyes wide open. They know what are the terms of employment. They worked only for a few hours. They were given liberty to work somewhere else also in the remaining hours. Correct?
Yes.
So it's not a kind of appointment where you're bound to a certain employer and being deprived of your. Now, see, in your order last time, you said that there's only one thing that troubles the court, that he said there's never any regular post of sweeper. Is that correct? In NIPCO, there's never been a regular post sweeper, and no such post ever sanctioned in
Earlier,
NIPCO.
Lordship, there have been. I mean, those are filled up through the due selection process.
No, but you see in your, this is a repetition. Yes, in your reply speaking order dated 20th March 2020.
Yes, Lordship.
With regard to their case, at paragraph 4 of that speaking order.
Yes,
Paragraph
Lordship.
4 at page
Yes,
27.
Yes, Lordship.
Yes.
Lordship, writ petition?
Yes.
Annexure 5, page 27B.
7.
27B.
27B.
That's seal number 4.
There is no such regular post of either sweeper or cleaner, and no such post is ever sanctioned by the NEPCO, and you also do not hold nay such post on ad hoc or temporary basis, and as there is no question of regularization of your service on the post which does not exist. Your Lordship, this is on the date of affidavit filing.
On the date of?
On the date when the affidavit is filed, that there is no sanction post.
But he brought the other documents showing that some were accommodated. Where's that, Mr. Jha?
My lord, that is that.
Or writ petition only?
In the writ petition itself, my lord.
That's the only thing, yes. That whether be given differential treatment or not.
Yes, my lord.
That's the only consideration.
Yes.
If it violates Article 14. Other rights, they have no rights. They have no vested right, rather. Which page?
Page 24A, man. 24A.
Yes. These were
List of
employment
regular
exchange. They were through all employment exchange.
If the employment exchange, my lord.
But
if
even if there was no post, your appointment was from when, Mr. Jha?
My lord, appointment was from the.
Which year?
Each year, 1990. My lord, it's.
Only thing from the court that if others have been given, they're small people. If somehow
we have made your lordship attempt 3 occasions.
Yes, we understand.
And finding no way. And these days your lordship, this type of jobs only part time everywhere. Even security persons are hired by the agency.
No, everything's outsourced now. Because
everything is becoming outsourced, your lordship. And there are no regular posts. Even on the regular post, people are being appointed on on a lump sum basis.
No, I'm saying since the appointment in 1990. Before, might
part
be not been irregularly appointed.
See, I have never heard that a part-time employee is regularized.
No, the question is...
Regularized on the part-time post.
No. Been regular, see, list of regular sweepers and cleaners, which has been given by the petitioner. That's the only thing that, if they were, then they should have... Even if they qualify or not, doesn't matter. But if whether they were ever considered, to be accommodated against those posts, they have to qualify. But whether they were ever taken into consideration, since these regular sweepers and cleaners posts,
they were satisfied, your lordship, with the part time because they have been working in different departments.
If they would have satisfied, why bothered this honourable court?
And that's why they never applied. There has to be, and
how did these people come into a regular selection, a regular post then? This annexure This page 24A. These
24A, Your Lordship, these
26 number of people who have been, risk or regular sweepers, cleaners. How were they employed?
These were employed through the regular selection process.
So there was the attachment for...
And Your Lordship will see their appointment letter.
Yes, where is that?
Additional affidavit, which I filed.
Mr. Jha,
My lord.
it's a, what do you call it, hard luck case, yes. Rejoinder, 92. Which page?
Lordship, actually this matter was heard on many occasions, so
No, this
I
is
thought he
because
was
of compassionate,
he was
compassionate hearing.
He was to only
Bring materials.
bring the case. That's why, Your Lordship, I am slightly. If it has to be reheard, I have to go through.
No, see why, Mr. General, the compassionate hearing. We know that he has to vested time, so he's just trying to show somewhere. And if there's element of, like some other people, they've been accommodated, that's the only thing troubling them in the court. That they cannot go back, if they come to the court, it's a duty to the court to, to duty, even if it's for justice. Yes.
Lordship will see.
Which selection committee was this? You have seen that, yes. The base of the recommendation selection committee, the following persons here upon the sweepers under NIPCO in the scale of PS so and so. See, because they're all working as contract labor. Now regularized.
Your Lordship will see page 9.
Yes, 9.
Of my
Yes.
last affidavit.
Yes.
Based on the recommendation of the selection committee.
Yes.
The following are hereby appointed. So these are on the basis of the selection committee. And Your Lordship will see their appointment letter. And these are subject to so many terms and conditions. Then you will see annexure page 13. The following persons are hereby engaged purely as part-time sweeper cleaner for doing sweeping cleaning time from 8 a.m. to 9:30 a.m. and 3 p.m. to 5:30 p.m. Which timing?
Understood. But means only that.
So Your
yes,
Lordship.
Mr. Jha.
Yes, my lord. My lord, they are showing annexure 1, my lord, of that.
Yes.
Yeah, the contract laborers, my lord. They are laborers, my lord. Here we are for the sweeper and cleaner, which 24A, my lord. None of the name of that has been reflected here, my lord, which has been regularized. If the post is, my lord, if the post is sanctioned, post is not there, my lord. How they have been regularized?
No, the thing is that we can't find anything. Now you mean to say that the names given in your petition, they're not appointment letters of those people are not reproduced?
Nothing. And if the basic question, my lord.
No, see, the stand of the respondent is that those people who have names appear there also, they have come through a regular selection process. That's all.
That is the
correct.
Respondent has to justify, my lord.
Now you're saying that they have justified it because they've shown upon orders of someone else.
Yes, my lord. That's a labor contracts.
Now those people in 24A, they all engage in the main office here.
They are in the
headquarters.
In the headquarters as well as in Guwahati, my lord. So why the respondent is not fair, my lord?
Has not?
Is not fair, my lord.
No. Even that the rights are very limited, Mr. Jha.
My lord,
the court wants to see the only thing, because no one should be treated unfairly. Correct.
My lord.
What to do this case? We'll dispose it off. Because even then we're not satisfied. List for these people you produce, Mr. Jindal. these people shown the list, how do you appoint it? That's all. The only query.
Affidavit to your lordship.
No, affidavit, no, you have not produced the appointment letters of these people shown in 24A. Employee code number so and so. Take down.
No, lordship, here in the affidavit we have stated, your lordship.
You have stated, but the thing is that with regard to this, none of those people, I mean, the names you showed, they're not part of this list.
Lordship.
Just show one name. Just upon letter of one person from this 1 to 26 will be satisfied.
One letter.
Just one appointment letter. How this person is appointed, this number 1 or number 4 or whatever. Just show a sample letter of one of these people who are in the regular list of sweepers and cleaners.
Lordship, which page number 9.
That's page 24A.
Which I have referred, your lordship.
That the names are not here. They're different people. They would have no quarrel. They have come to a regular selection process. They've been appointed, but it's one of these names.
Because this was produced as per the direction of this honourable court. Your lordship wanted that produce a specimen letter of the regular appointment. So this was produced.
Specimen letter of regular appointment, one of these people at least in the list, the 24A. That list which you've shown, see, it's if what it says correct. See, the list that you annex is Tabayaza, Takotania, they all in Arunachal Pradesh. Nanda Sai, Tapa Tapin. This name's not here. These are all these. They all.
Because this was lordship wanted only a specimen of the regular appointment.
But a specimen you give of not of one of these people on the list. That's the only thing.
All right, lordship.
That's the only thing. I just close it. This matter was has been heard had been heard in length. The only doubt that remains with the court is the manner of appointment of the list of regular sweepers and cleaners, which is annexed as Annexure 3 at page 24, bracket capital A of the writ petition. Stop. Mr. V.K. Jindal and Senior Counsel so-and-so, praise him allowed to produce a appointment letter of one of the 26 people who are shown in the list. Yes. By 1 week, we'll dispose of, others will dispose of. No, right. Mr. Jha, just to satisfy the court and satisfy you also. Because the small people, we feel the court also has a duty to. No one unfairly treated.
I came with 60% small people, but we couldn't get anything.
Oh, that is different. That is different. Because it's clear. Here, one thing is clear, it's over. Yes, Mr. Pandey.
This is a disability pension, Lordship.
Your Lordship, before my learned counsel for the petitioner's advances.
With Dr. Mozika?
Your Lordship, he's on legs before the single bench.
What's
there are
a
bunch of 15 matters, Your Lordship, which has been listed for fixing of dates today.
So what do you want to do?
Your Lordship, if we can have it sometime next week.
But is he entitled or not?
Your Lordship, invalid pension, I would say he will not be entitled because he's only rendered 2 years of service.
Lordship, I'm not seeking invalid pension, Lordship. Yes, Lordship.
Disability.
Lordship had already, in the last occasion, observed, Lordship, that, his injury is attributable to service, Lordship, and he's received 40% injury, Lordship. And there is no ceiling of 60%, Lordship, as per their own later, Lordship. So they had sought some clarification.
Let Dr. Mozika come. After 1 week, yes. We'll dispose of next day.
Lordship.
After 1 week, at the request of MS Ramthao, due to unavailability of senior counsel, to engage in court number 1. Yes.
31.
Yes.
Please, Your Lordship. So far, I think petitioner, they have completed their submission now. Reply from the NEGU.
What is the submission of the petitioner?
No, this was basically, my lord.
That you're working from home?
Yes. And ultimately.
My lord, I was working in the Department of Zoology.
Of?
My lord, can you hear me, my lord?
Yes, I can hear you.
In Nehu, my lord. My lord, this is about the condemnation of delay, my lord. Where I had been working during the COVID time. However, they have taken that period as.
Yes. What happened to him? What happened to Zapala? You know the fact of the case? Yes, next matter. Last one. Did he argue physically last time?
No, BC. Through BC. All through BC. In fact, last occasion, my lord, he has concluded his submission, so I was supposed to answer, whatever it may be.
Answer? What do you answer? It's only a question of regularizing relief.
My lord, what happened in this case, the petitioner was working in the Department of Zoology. Now, during COVID time, before COVID, my lord, she applied for 3 days leave with the permission to leave the station. 3 days. She left the station, my lord, went to Calcutta. She's basically from Calcutta. She was in Calcutta. So after the leave was granted, what happened, my lord? That COVID notification came. All those restrictions came into place after the leave was granted. So, my lord, that unusual situation arose. Now, these continued, my lord, till the month of March. There was total restrictions. Well, there was total. Well, there was no activities at all, Your Lordships.
Let's see if he comes on. What's wrong?
Network issue, Your Lordships.
So, my lord.
Not from our side. Not from his side.
Network issue.
Let it come up tomorrow, Your Lordship.
Tomorrow?
Whatever, Your Lordship.
List tomorrow. Due to technical issues, the hearing cannot be concluded. List tomorrow. What happened to his
Network problem, Your Lordship.
उतर लीजिए